So thank you again for joining us today for Survivor Rights in Campus Response to Gender-Based Violence. Today we have legal consultant Emily Austin here with us today, and she will be presenting for you all today. So Emily, thank you so much for joining us. I'll turn it over to you.
Great. Thank you, Priscilla. It's a pleasure to be back here. I've worked with Valor for many years, and before that, I worked at a local rape crisis center and domestic violence program, Peace Over Violence. And I also worked at the California Women's Law Center, where I started to work on systems change and policy change. And I'm really happy to be here with you today to talk about victims' rights, to give you access to the state resources, and to start to kind of understand how having survivors know their rights is part of a trauma-informed response, and how law enforcement and community partners can come together to make sure survivors know their rights and can exercise their voice and choice. So this is just a brief overview of what we're going to do today. We're going to talk about the idea of victims' rights, where it originates from, and kind of what the purpose is. And then we're going to talk about California-specific survivor rights that circle around the issues of gender-based violence. And these rights should impact all folks, whether they're on a college campus or not. These are universal ways that law enforcement works with survivors, and universal requirements that survivors are notified of these rights. And then we'll finish up by just kind of circling back to why this is a trauma-informed approach and ways to bring that thoughtfulness into how we talk about survivor rights. You'll notice today that I'll kind of use victim and survivor interchangeably. Survivor is a very advocacy-based term and tends to center survivor choice. It talks in a more positive way about healing, and kind of it's a way that we as advocates a lot of times feel very comfortable talking about people that have been impacted by violence. However, the criminal justice system calls persons impacted by criminal acts victims. And so we'll see that as far as how we legally talk about it, a lot of times it's couched in the terms of victims' rights. So today I will kind of go back and forth using those terms interchangeably, but do know as law enforcement or working with law enforcement that the way that they are trained, how they're thinking about persons that are impacted by violence is often as victims. And so we kind of hyphenate it in our advocacy, right? So we kind of go between victim, survivor. All right, so first piece is, what are victims' rights or survivor rights? And these are protections for people that are impacted by crime, impacted by violence. In our case, we're looking specifically at the intersections of gender-based violence, domestic violence, dating violence, sexual assault, and stalking. But victims' rights include destruction of property. It also includes, various forms of assault and battery that may not be connected to gender-based violence. So victims of crime is a even bigger term than our issues, and our issues that are looking at gender-based violence are housed within the larger scope of victims of crime. So victims' rights came about from survivors of crimes and of violence feeling like they were not well informed about the criminal justice process, that they didn't know that they had any standing, they had any choice in the matter. And so our legislature and leaders have created protections for victims of crime so that they are more aware of their ability and their choices in how they interact with law enforcement, or they interact in the investigation, or whether they have to go in and provide testimony during a criminal trial. All those kind of pieces we needed to inform victims and not require that victims had to have legal representation in order to participate in the criminal justice system as a survivor of violence. So we've created these laws, they're written into law. All of the ones we'll talk about today are required. Two of the victim rights laws that we'll talk about, part of it is to require a notice or a posting, because one of the common experiences of survivors of crime, victims of crime, is that they may not know what their rights are. And so we need to provide a required mechanism for them to be notified of those rights. So, and a standardized mechanism. So no matter where you are in California, you're going to get notification of your rights. And, you know, a lot of the guidance from this comes at the state level from the Office of the Attorney General, and also our local rape crisis centers, domestic violence shelters, and programs know a lot about these rights and notification laws because they work with survivors and want to make sure survivors know their rights. So here are some of the reasons why it is important to have victim rights. And it really circles around these tenets of public policy that survivors and victims felt very traumatized by the criminal justice process. They felt like they didn't have any standing on whether they participated or whether they didn't. They didn't get updates. They kind of felt like sometimes they would call on law enforcement and they wouldn't ever hear anything again. And so survivor rights, victim rights kind of came up to protect victims from a process that could do them harm and that they felt like they didn't really understand. It gave them some protections that come from knowledge. And it also builds trust. So really important for law enforcement and for victims who are often these eyewitnesses to crime to have a trust-filled relationship. When you have trust, you're more likely to show up for each other. You're more likely to want to participate in the process, and you're more likely to feel like you're empowered to make choices within the process. That really, you know, helps survivors in their healing, but it also really, really helps law enforcement officers, because when survivors want to engage with them, we see in the statistics that there is a much higher conviction rate if that is the goal. So if our goal is to convict and get these prosecutions through, when you have survivors involved, you have a much better chance of getting to some sort of finding. It also restores hope. So survivors that are not know about their rights feel like the process is filled with some sort of hope. It gives them some kind of understanding of the length of the process, of who they can talk to, of what their rights are on getting updates, and builds that kind of resiliency by showing that the state and law enforcement cares about what happened to them because they are showing these rights, and victims have these rights. Then it improves transparency and accountability, which we know is a central tenet for trauma-informed care and approaches. Is having a more transparent process allows people to have more faith in the process and have more trust in the process itself, not just the people, but in the process. And the accountability piece is really important, because without some sort of accountability, then we don't have a lot of trust in what's going on. We don't really know that our rights are going to be upheld, or, you know, what even the process is. So having transparency and accountability is really central to a purpose on why victims' rights are needed and why it's part of our trauma-informed approach. And the final piece is that, you know, several of what I've already talked about touched on this, but it empowers survivors. So knowing your rights is a great way to empower survivors and small dogs. No, just kidding. but being able to empower survivors through a knowledge of rights is central to a trauma-informed approach, but we also know that it is central to healing, especially in the issues of gender-based violence, that these forms of violence are very intimate and very painful and very eroding of trust, self-efficacy, and belief. So being able to give and empower and support, allows survivors to empower themselves through knowing their rights is really, really important. And for all the advocates on this call, I know you completely understand that. And if you've worked with survivors, you know that part of our approach is just to listen and to support and provide the space for survivors to find their own empowerment. Knowing their rights is part of that, is an integral part of that. All right, so the first one we're going to talk about today is Marsy's Law, and I'm going to launch a poll to see who has heard of Marsy's Law before today. So if you have heard of Marsy's Law, I'd love to see. Oh, this is great. Okay, we're at about 64%. I like to get up to about 70% participation. So if you're able to click it, that's great. All right, wow, perfect. We're at 75. I'm going to end the poll and I'm going to share the results with you. This is great. I'm glad you all are here today. We have some experts that I really encourage to engage. I'm very bad at monitoring the chat while I'm presenting, but Priscilla promised to interrupt me if there's any questions in the chat. And then we have 30% that's somewhat familiar with Marsy's Law, have heard about it, but may not know the specifics. And there's over 50% of us have never heard of Marsy's Law before. And I think that's really interesting. I think you may not have heard of it called Marsy's Law, but you may know that survivors do have rights. So perfect. The California Constitution is actually the place where Marsy's Law has been solidified and is written into law. And this came out of a horrible murder of a girl in California by her ex-boyfriend or ex-husband, I believe. And they were not aware of any of the rights they had. And it really was a horrific kind of experience of not knowing what the process was and not being aware of any say or choice that they had as victims in the process, and feeling traumatized and re-traumatized by the process. So it's in our California Constitution, and sorry, this got a little messed up in PowerPoint, but the components are pretty exhaustive. So we're going to go through each piece of Marsy's Law, and this applies to all victims of crime. So not just around sexual assault and domestic violence, but around all different very ways of being exposed to violence and crime. So the first piece is kind of a gray piece about being treated with fairness and respect for privacy and dignity, be free from intimidation and harassment through the criminal justice process. So to be treated fairly and respectfully through the process, that is one of our components of our Survivor Bill of Rights. You'll also hear of Marsy's Law as a Victim's Bill of Rights. And so that's kind of an interchangeable way of thinking about it a little bit. The next piece is to be reasonably protected from defendant and persons acting on behalf of defendant. So this really plays into defendant harassing or intimidating the survivor, or their lawyer doing that, or someone else acting on behalf of the defendant, like family. So you have a right as a survivor to be protected from that, reasonably protected. And that means that, you know, law enforcement in some cases will not be able to assign an armed guard to protect in all cases, but depending on the circumstances, they have to provide some form of protection. It could be by enforcing and acting on a restraining order. They could give you an emergency restraining order, a criminal justice restraining order. They could have, for various other things, they could respond to your calls if the defendant is showing up or a person is intimidating you, or they could have someone outside your house protecting you. But reasonably protected is a legal term, and it means that given the circumstances, what would a reasonable person expect a form of protection would look like? And it could depend on the threat level of the defendant. So the third part is to have the safety of the victim and the victim's family considered in fixing the amount of bail and release conditions for the defendant, right? So this is a requirement that victims, the safety issues for victims are part of the calculation on the bail amount. The higher the bail amount, the harder it is for it to be, for the defendant to be released. So the higher bail amount reflects a greater concern about the victim not being in custody, or about the defendant not being in custody. And their threat level for the victim and the victim's family should be part of that calculation. The number 4 is, it's part of this component is around holding confidential information. So preventing the disclosure of confidential information or records to the defendant, that, or to someone acting on behalf of the defendant, like the attorney, that could be used to locate or harass the victim or the victim's family. So there's a right to not have your address given to the defendant or the defendant's lawyer or person acting on behalf of the defendant. And the same made about medical or counseling treatment and disclosure of confidential communications. Those things can often be used against survivors, as we know in our long history of victim blaming, to impact the case, as well as they provide points where people can find persons in order to intimidate or harass or abuse them. Then you have a right as a survivor to refuse an interview or discovery request by a defendant, and to set reasonable conditions for the conduct of such interviews if you consent. So really important is that victims and witnesses do not have to take an interview or do a deposition or respond to a discovery request by the defendant. And in our legal system, a lot of our processes are trying to get information from both sides in order to uncover the facts and make a finding. But survivors are protected from having to disclose information. It's part of their Bill of Rights. We can understand, from working with survivors, that these interviews and depositions can often be very abusive in and of themselves. And especially some very aggressive attorney tactics are to, break down and harass and abuse survivors and witnesses during interviews and depositions. So this is an ability for survivors to say, no, I'm not going to do that interview or that deposition. Whereas in civil cases, this applies to the criminal case. In civil cases, you may not have those same protections because the issues are different. So in a civil case, you would be the survivor would be the plaintiff, and they would be trying to get information to win the case in the civil court, which is usually about a money settlement, a money or an injunctive relief. Whereas criminal justice, what's at stake here is another person's freedom and liberty. So, oftentimes the courts will really require there to be a discovery that is complete, because the defendant is not just giving up money, but they're giving up their liberty, or not, they could be losing their liberty for the failure. But California, just because this is really important for survivors to know, California stands behind survivors here, saying that they get to make the choice about what if they engage in the interview or deposition process. Number 6 is, survivors need and have a right to reasonable notice of and reasonably confer with the prosecuting agency. So that's with the DA's office upon request about the arrest of the defendant, the charges filed, determination on whether to extradite the defendant, move the defendant out of the area, and be notified if you request of and informed of any depositions of the case. So any pretrial agreements of the case. So this is really important for survivors to know, because you have to ask for it. You have a right to it, but their law enforcement is not necessarily going to give you this notice and give you this information unless you request it. But you have an ability to find out exactly what the charges are and if there's any pretrial decisions about the case. The next piece is, this is very exhaustive, but it's great to know for us working with survivors, and we'll get into how we share this with survivors in their contact with law enforcement. So 7 is survivors have a right to reasonable notice of all the public proceedings, including delinquency proceedings. So if the defendant is delinquent or not shown up for something, the survivor has a right to know, and also about parole or post-conviction release proceedings. And the survivor has a right to be present at all such proceedings. So I've worked in county prisons and where survivors have shown up to post-conviction release proceedings to talk about their fear threat level. And they have a right to be present at those proceedings and a right to have notice of them, so that once someone is in custody and has been convicted, that whether they're released or not needs to be something that is told to the survivors, and that survivors know they have a right to that notice. Then survivors also have a right to be heard at any proceeding. So we have survivors that do show up in post-conviction proceedings to talk about their concerns about a person being released, and you have a right to do that. The next piece is you have a right to a speedy trial and a prompt and fair conclusion of the case and any related post-judgment proceedings. Really, we all are under the US Constitution and the California Constitution writ large, we all should have a right to a speedy trial, but we are underscoring it here for survivors. So part of that, the pact we're making with survivors and how we're trying to hold persons that cause harm accountable is we're trying to do it in a timely manner. So speedy trial means that it's not taking years. We're talking hopefully within a year, not a decade, to find a conclusion to a case. Then 10 is to provide information to the probation department conducting any pre-sentence investigation on the impact on the victim and the victim's family. You have a right to provide that information. So you can fill in the story for probation when they're making determinations on what they're going to sentence or ask for in sentencing for the defendant. And then the next part is to receive upon request any pre-sentence report available to the defendant, except those pieces that may be confidential by law. So there may be some things that are redacted or held out of that report in order because of the defendant's Fifth Amendment rights or, various protections, but survivors do have a right to that pre-sentence report. So that is all the information that goes into determining what sentence the prosecuting office is going to ask for the defendant. Again, about trauma-informed and about transparency. A lot of these things really touch on the transparency requirement for survivors. The next piece is, you have a right to be informed of the sentence and the conviction, where the person's incarcerated, and if there's a release of or escape of the defendant in custody. So this is really, moving past the pre-sentence piece into the conviction and where the person's being held. A survivor has a right to know that and to be notified about a release of the defendant or the escape of the defendant. The next piece is restitution. So survivors have a right to restitution when possible. And that is part of this trauma-informed approach of trying to heal harms. So restitution is part of a survivor's right. It doesn't mean you always get restitution because some people cannot pay, but you have a right to it if any is taken. And then there's an intentional piece that, around restitution, that we want to support people to seek and secure restitution from people convicted, and it'll be ordered from a wrongdoer in every case, regardless of the sentence. And the money that's collected will be first offered as restitution to the victim. So that victim is first in line as far as kind of quote unquote creditor for any restitution taken from the person that caused harm. Then 14 is to a prompt return of property when no longer needed as evidence. So if your car is taken into evidence, or clothing or jewelry or anything like that, the law enforcement can't sit on it and keep it forever, only for as long as it's needed as evidence. 15 is to be informed of all the parole proceedings and participate in those processes. So even, if there's any discussion about early release, or the survivors have a right to have a voice in those proceedings. And, when you're considering parole or early release, the safety of the victim and the victim's family, not just the conduct of the defendant in custody, have to be considered. So that really is where survivors have an ability to impact the process by showing up into those settings and sharing what the impact of that person's release will be on them. And their threat level of the defendant needs to be considered by law enforcement and by any prosecuting agency when considering parole. And then the last piece is the notice requirement that I talked about before. So all of those rights, 1 through 16, the survivor has a right to be notified about those requirements. It's really important that survivors have a physical copy of these rights and have notice when they have contact with law enforcement. So the next part is talking about the card. Yeah, go ahead.
Before we move on to the actual documentation, we do have a few questions in this.
Okay.
So first off, Rebecca from Pennsylvania said that they passed a law back in 2019 for Marsy's Law. And she's saying that the ACLU listed some opposition as well as the League of Women Voters, and wondered if you could speak at all to some of the pushback that we saw around the country in some states, knowing that some of them were specific to those states.
Yeah, I think just honestly, I work in a lot of restorative justice. I work in looking at civil rights, and I think a lot of the pushback is related to the criminal justice system, and it's in some ways criminalization of poverty, in some ways how law enforcement has been unequally, persons of color are more likely to be caught into these legal systems and stuck in them. And the ACLU is very concerned with individual rights. And so they often are taking the position of protecting the person who caused harm, right? So they are trying to reduce the requirements on the person that caused harm as part of their individual rights. And that's why ACLU is often opposed to things that put more onus on the defendant. Another piece of our process is there needs to be an equal and fair legal process, which means that survivor voice can't be more important than defendant voice. It has to be an equal and level playing field for determining what happened. So in some cases, especially that one provision I talked about for a bit, about the victim witness not participating in investigations and depositions, means that the defendant is not able to get that information to prove their case. And from a legal standpoint, that is putting a little bit more weight on the scales for the survivor. We know that it is can be a very harmful process for survivors. For folks that are in that process, it can be a withholding of information, which is what ACLU is very concerned about. League of Women Voters, I'm not sure exactly what parts they were against, but they may have been concerned about general equity and justice. Also, they may have been concerned about just the impact of the legal system in general. Like, I do a lot of work outside of around accountability that's outside of the legal law enforcement criminal justice system, and putting more resources and onus on persons in the system that are often poor, that are often persons of color, can feel inequitable and unfair. Did that answer?
I think so. We do have a couple more questions though.
Okay.
Some folks are wondering if there are any laws similar to Marcy's law on the federal level, or if they're only implemented at a state level.
So we really don't have a federal Marcy's Law or Victims' Bill of Rights, but each state, and I believe I was just looking on the Marcy's Law for All website, I believe that about 30 or 40 states have some version of Marcy's Law in their constitution or in their law, in their legislation, in their state laws. Do know also that it kind of works best and connected to state law enforcement, because that's where the majority of our crimes are prosecuted. Federal crimes are prosecuted when they have a connection to the federal government, such as when something is crossing state lines or where there's jurisdiction at the federal level. But really at the state level is where most of the issues of gender-based violence are going to be heard and decided. So I feel strongly that it should be at the state level. And I'm not aware of anything at the federal level that's like an umbrella policy that has passed.
Okay, thank you. And then Rebecca did give feedback that yes, it did answer her question about the pushback. And then our last question is, what are the consequences if these rights are not honored?
That's a good question. So, I mean, there's no written like fee or consequence that a person can easily pursue. However, you could pull into civil litigation the law enforcement office for not following or providing these rights. So these rights provide a backbone for a lawsuit against law enforcement that is not protecting survivors and not upholding survivor Bill of Rights. Whereas there's not an explicit thing like failure to provide the rights is $1,000 fine from the law enforcement office. It does provide the context for pursuing a civil case or getting a settlement. What would happen in a lot of these cases, I did do some active litigation against different police departments at different times, and you were able to engage with their legal counsel and get a settlement for not fulfilling these rights. So it's mostly on the civil side. There's no criminal penalty for not upholding them.
Thank you, Emily. Those are the last of our questions.
Okay, great. So going back to number 17 of the California version, and it's great. I love all the state pieces, and please just search for Marsy's Law in your state, and you'll be able to get pretty easily connected with the area of your law where if it's been adopted. And there's ongoing push to get this adopted in all states. There's a website, marsyslawforall.org, that is tracking that and pushing that campaign. So in California, I'm just showing an example. We have, Office of Justice programs, and we have a requirement that each victim at first contact is notified of their Marsy's Law rights, their Victim Bill of Rights. And as you can see, it's kind of an intense card. This is a blow up version of it on the side. There's contact name, info, and police case report number. So the information is on that card for the survivor to reach out to law enforcement and have a way to get to the person working on the case. And then it outlines in kind of more basic terms. I went through the legal language. This is kind of more the layman's language of the 16 enumerated rights. And that way you have that as reference from the first contact. The really role for law enforcement is to make sure that survivors have this card with them with the top part filled out, so they know who to call if they have questions, and that improves accountability and transparency in the process. All right, so that is our general Marsy's Law. And we talked about, I tried to highlight what pieces are, super important for survivors of gender-based violence. But in California, we also have a Sexual Assault Victims Bill of Rights that I wanted to go through with you. It's called the AB 1312 card. So if you're not from California, you may not know this one, but has anyone heard of, or maybe you might have one in your state too, of the AB 1312 Sexual Assault Victims Bill of Rights? All right, if you could fill out that poll for me, that would be great. Perfect. Thanks, everyone. We're almost there to my threshold. All right, we're over 70% participated. So, okay, great. We have some, again, it's kind of similar. We have a little bit of a broader split between folks that have never heard of it and some people that are somewhat familiar, and we have some experts in the room too. So please, if you wanted to add any, pieces to what you're hearing today about the Sexual Assault Victims Bill of Rights, please do so. I know formerly CalCASA, now Valor, has been working on this issue since it was passed in California. And we've been really trying to engage our California Rape Crisis Centers in being a person that knows about this notification requirement and helps law enforcement. All right. So the Sexual Assault Victims Bill of Rights really has come out of the experience for sexual assault victims in particular, and the disparate impact of sexual assault survivors have a lot of specialized rights that are different maybe from just general victims of crime rights, and in California and in other states, but there was no notice of them. So if you don't know your rights, it's almost like they don't exist. So part of the big problem in California was that survivors had protections and rights, but they never felt like so many times survivors went through the process and didn't know about those rights, especially if they didn't have access to an advocate that knows those rights. So we wanted to make a difference. We wanted to make a better relationship with law enforcement, and we also wanted to inspire trust in the process for survivors. So we were able to pass a law that enumerated sexual assault victims' rights and required that law enforcement provide a card with those rights to survivors. Sexual assault has some intersecting issues, such as like timely collection of evidence with a SART exam, protections about being called in to testify, called into the process, protections about whether to participate in the criminal justice process at all. And we wanted to make sure survivors knew about those as soon as possible. We also realized that just having someone speak or tell someone that has just experienced trauma their series of rights was not very trauma informed. That it's very hard to take in that amount of information when you've just been traumatized by such an intimate and horrific crime. It is unrealistic to think that someone, a survivor, is going to be able to understand and comprehend their rights, and even that they're able to make a choice that is right for them in that immediate moment after trauma. So having those written down is really important for survivors to be able to reflect on and be able to get counsel, whether it's a community advocate or family or friend, to kind of think through their rights and what they want to do. And so it's really about empowering survivors to make choices by letting them know what their rights are. So the first piece is that a sexual assault survivor has a right to ask questions of police, nurses, and attorneys. We found so many times that survivors felt like they couldn't ask anything of law enforcement, or ask what nurses were doing during an exam, or talk to attorneys about what was happening. And so they were very shut out of the process, and it wasn't survivor centered. So it seems very clear that you would have a right to ask questions, but we wanted to enumerate it for survivors so that they knew they could always ask questions of police, attorneys, and nurses, anyone that was talking to them. It was not a one-way relationship. They were a part of the process. Again, it's sad that we have to write this out, but survivors have a right to be treated with respect, no matter what the circumstances are. And, we saw that in Marcy's Law. We have two different places and two different rights notifications in California that you have a right to be treated with respect. You have a right to have a victim advocate present for any of the contacts related to the case, right? This is very powerful for survivors to be able to have a victim advocate present that can help them in standing up to ask the right questions, can help them think through what they want to do. And we know, if prosecution is the goal, we know that when victim advocates are working with law enforcement, that there is a higher conviction rate. So, having a victim advocate present also improves the process, the criminal justice process, as far as convictions. The next part is that sexual assault victim has a right not to be charged any cost for medical examination for the purposes of gathering evidence. So it's important for survivors to know that, because they may walk into a hospital and then get a bill. And if they don't know they have a right to not be charged, they may even pay that bill. We know that survivors have been charged for that. So it's really important that any of the cost of medical exam for the purposes of gathering evidence is not chargeable. Now, if there are other abuse, harms that is not around medical examination, that may be charged to insurance and may incur a cost. But the cost for the medical examination should never be charged to the sexual assault victim. And law enforcement needs to know that, as well as anyone who works with survivors needs to know that. Then the next piece is that the proper rape and SART investigation protocols need to be followed. All hospitals that are doing these exams have to follow the proper rape investigation protocols. And in California, we have those enumerated, and SART nurses have an advocacy group about the proper protocols. And those investigation protocols have become more and more trauma informed and should be trauma informed. So if the proper protocol is not followed, that person may have a case against the institution that conducted the exam. You also have a right to free pregnancy, venereal disease tests for sexual assault victims at county hospitals. So the important piece here is that it's free, you should not be charged for it as a victim of sexual assault, but also that maybe some hospitals, private hospitals and hospitals with religious affiliations may not provide this sort of these tests and these supports. And so that is an issue in looking at what hospital you're at, or what where you're getting your sexual assault exam. The reason for that is California and federal law, that because some hospitals may have a values and religious reason for not providing contraception or various different protections around sexual assault. So making sure that you're in the right place may be important. However, each hospital should have a protocol for responding to sexual assault exams. It may be that they do not process those exams in the hospital, but they have a relationship with someone who does. Then we have a right to receive victim assistance information regarding state compensation to sexual assault victims in the county hospitals. This is because this is what the state can control. The state can't control what's happening in those private hospitals. There's also a right to have a crisis center notified before the medical exam. So you can understand why knowing these rights at first contact is really important for survivors, because they may not know they have a right to have an advocate present. They have a right to have the crisis center called before the medical examination. And for anyone who's worked in advocacy, you know how difficult, traumatic, and important it can be to have someone there during a medical exam, just someone there on your side with you. The next piece is the right to have a sexual assault victims counselor and support present during the examination, right? So like those two go together, and for the same reasons of trauma-informed care, as well as for healing and centering survivor choices, you have a right to have then notified, and you have a right to have a person there. You also have a right to have a victim advocate accompany the victim to the witness stand during court hearings in any contact. I mean, this is a little repetitive because it already said any conduct, but we wanted to make sure that they knew that during court hearings, they didn't have to go alone, that they could have a victim advocate present. The victim advocate doesn't have standing to say anything, but they are there as a support person. They can be there as a support person. A right to be anonymous during the court proceedings. So to not have your name included in the court proceedings, that is really important for survivors to know, because they're going to need to exert these rights, right? So part about notice is then you need to be able to say, I have a right to not have my name disclosed. And you can prohibit law enforcement from disclosing your name and address, the survivor's name and address, for obvious reasons. And a right to learn custody status of the defendant prior to conviction. So knowing whether the defendant is in custody or not before they are convicted. Again, this kind of relates to Marcy's law on the bail requirements, making sure that also there, the safety of the victim is supposed to be in consideration. You're also supposed to know whether the defendant is in custody or not while awaiting conviction. Then again, but enumerated separately, here is the right for notification of release or escape from prisoner in jail upon conviction, but you have to request it. One of the key themes of this, and why I'm glad we're going through it, and it sounds like we have a great mix of law enforcement, of advocates, is the more people that know about these rights, the better we are able to communicate and kind of, if something is violating these rights, we'll have a feeling like, hey, that's not right. And it's more than a gut feeling. Now you can go actually to the law and say, actually, you're not following California state law. So the other piece is that law enforcement agencies were charged with developing a card that explains in clear language the rights of sexual assault victims and is accessible to each provider of medical evidence or physical examinations from sexual assault. So again, this puts the onus on law enforcement agencies to develop a card. California has a state template card. Valor has a card also that I'll show you. I'll show you guys some examples, but it's important that we understand that this charge is on law enforcement. We want to work with local agencies to make sure it is in clear language, talking about the rights of sexual assault victims, and it's accessible to everyone. And it's really important that the card is like a physical card, because people need to be able to take it with them and not have it be just linked on a website somewhere. They need to have a physical card to take with them after first contact with law enforcement. So here's our sample card from Valor, and I'm going to ask, could we put in the chat? Perfect. Thank you, Ashley. Thank you. So do know that our Valor template is, I believe it was translated into Spanish also, but this is the English version. Do know that Marsy's Law and the California version of the sexual assault rights card is available in multiple languages. And those links that we put in the chat allow you to download it in multiple languages. So again, this is a lot of, information in a small pocket pamphlet. And you see these blank spaces here. It's really important to connect people with their local rape crisis center for ongoing free support, and that you have a contact for law enforcement and medical provider on these cards. So we even have a place you can put your logo if you're an advocate, so you can kind of brand and create a comfort level with the survivor so that they kind of understand that this is a local agency that does this work, and you can reach out to them to help you with all enumerating those rights, especially having an advocate present at various stages of the process. So this, of course, includes, a right of financial assistance. And what we did here is combine some of the Marsy's Law rights with the sexual assault specific cases, and especially around confidential access to confidential information and counseling. So this is the front part, and this is the other part. Again, we tried to make it easy to read. And in the blue box in the center, we enumerate that you have a right to know the DNA and other types of evidence degrade over time, because that was part of the issue around AB 1312, was that survivors didn't know that if they waited to do a SART exam for a period of time of if they waited a couple weeks, that some of the evidence would be destroyed over time, and then it starts to break down. And then we wanted to enumerate that there are time limits to this, that you have a right to know what happens to your rape kit. And, what's really important is you have a right to know if there's any hits or matches to the DNA profile from law enforcement, from participating in a SART exam. You also have a right not to have a SART exam. So making sure survivors have understanding about these requirements. So there was a lot of and the backlog in LA I've worked on, and in California, and a national movement to reduce the backlog. In California, we have a state law that if evidence related to your assault, it will be tested. It needs to be tested and analyzed within 24 months, which isn't like the shortest amount of time, but at least it's not decades. So the other thing is that the evidence in California must be kept for 20 years for victims under the age of 18, or for victims under the age of 18 until your 40th birthday. So that allows survivors to have that evidence until they're older, and your feelings about what you want to do with that evidence may change. You also in California have a right to request in writing and receive a free copy of the initial crime report related to your assault. So again, this is about transparency and making sure survivors understand what was written about the crime. And then you have, if your assailant is convicted and required to register as a sex offender, you have a right to request their sex offender registry information from the prosecutor. So again, a couple of these really require you to request the information, but no one knows to request it if they're not aware of their rights. So it's really important for survivors to know their rights and hold on to this information so they can continue to make choices about their case. And I love, we worked on this front part. The other piece is you are never required to participate in the criminal justice system or receive a physical exam in order to keep your rights. We had heard tales and stories of persons feeling intimidated and harassed that if they didn't participate in the criminal justice system, or they didn't get a SART exam, that, or just they were just expected to participate in those things, and they didn't know they had a right to refuse. And you can choose whether to get an exam in California or not, but also under federal law. So this is under the Violence Against Women Act. You have a right to a confidential SART exam, which means, or we call like a Jane or Jack Doe SART exam, where you will get a SART exam that's nearly the same process as the full exam. It will be assigned a number and not tied to your personal information and stored for you. And then you can decide whether or not you want to participate in the criminal justice system at a later date. But at least that evidence is preserved for you, and then you can make a choice later. Again, as we know, all the advocates and persons that have worked with survivors know that this trauma is, long impacting, and it can really take a while to figure out what healing looks like for you, what healing looks like for each survivor. We're trying to build a process that allows survivors to make different choices and to change their mind during the process, while preserving as much information as we can. All right, I'm just going to pause there just for a second, just to see if we had any questions, or if folks wanted to ask a question about the sexual assault victims' rights law card in California.
No questions so far in the chat.
Great.
But, if anything pops up.
Great. So the last area we're going to talk about is domestic violence victims' rights in California again. And, what is important here, what's a little bit different, is there's no notice requirement in the domestic violence victims' rights laws. But we feel very strongly in working in this intersection of gender-based violence that we as advocates need to get this information into survivors' hands. So creating and or partnering with domestic violence shelters to have some sort of law is really, really important. Again, we're talking about forms of violence that are very intimate and often very complex. There's often very complex relationships with the person that has caused harm. There can be children involved. There can be stalking and, very, intimate understandings of between the survivor and the person who caused harm. So knowing your rights is really important, and being able to engage in the law enforcement in the criminal justice system and work with law enforcement in order to get protection can be extremely important. You'll see in these ones, a lot of these issues kind of circle around the intimacy and the relationship between the survivor and the person who caused harm. So the first part is that survivors really need to be aware of the expanded definitions for domestic violence, because even when we say domestic violence, it makes it feel like it has to be happening in a home or in a formal relationship. So it also includes protection against former spouses and cohabitants. It includes dating relationships. So it doesn't have to just be marriage. It includes all different types of relationships, LGBTQ protections for various relationships. And it's not just between married spouses. Then the next part is really that law enforcement can take temporary custody of a firearm at the scene of domestic violence. So if they are in the house or in an area, they should ask if there are any firearms present, and they should take temporary custody of firearms at the scene. We know that gun violence and domestic violence are very related. And we also know that when having a firearm in the house with someone who causes harm is, even if it's not being pointed at a person, it is an underlying threat and intimidation just by the fact that it is in that house or is available to the person that caused harm. You also have a right to call the law enforcement agencies to prepare written reports for all domestic violence calls. So anytime there is a domestic violence call, law enforcement agencies need to prepare written reports for them. What we were finding in the history of this before was that domestic violence calls were just coming in but not being documented. And so, a survivor would say, well, I've called law enforcement like 15 times about this, but there's no proof of those calls because no written reports were created. And that really impairs survivors' ability to get custody, be able to do things to protect themselves, and it takes away from any kind of building of a case to get any sort of criminal justice help. You also have a right for law enforcement to serve the offender with the restraining order in the scene of the incident or anytime the offender is in custody. So law enforcement serving the defendant is important because this can be highly volatile and it can be very dangerous for whoever is getting served with a restraining order. At the scene of the incident, it could be an emergency restraining order that is approved by a judge on call, and that person can be served by the law enforcement officer that's at the scene. And then anytime the offender is in custody, we have historically had trouble serving persons with restraining orders. Some folks felt like if the offender's in custody, why do we need a restraining order? But it was important to have that offender served with a restraining order in case they were released in any moment, making sure that restraining order is in place. Because that also, restraining orders in domestic violence cases can make determinations around custody and property division, which are very important for survivors that are trying to take care of family and trying to seek healing. The next right is really to address confidentiality for victims of domestic violence and stalking programs. So that is administered by the Secretary of State's office, and it should be levels of protection for victims of domestic violence to prevent ongoing intimidation and harassment, and also with stalking programs that can be correlated with domestic violence, but may be separate, again, to prevent intimidation and harassment. The next one is the right to have a support person in court throughout the appearance, including any mediations. So having a support person, we know as advocates, super important. Just as in sexual assault cases, in domestic violence cases, having an advocate can make all the difference for supporting survivors. And then the next piece is to have a counselor or support person present at interviews with law enforcement. So you have a right to have that person in court, and you have a right to have that person in any of those contacts with law enforcement that are interviews, especially, and we would urge folks when they are having meetings with defense attorneys to have that support person also as just a witness to behavior and intimidation. It can be really important to have that second set of eyes and witness in those spaces that can be very intimate and be very charged. So I like our Marsy's Law, but specific to domestic violence, you have the right to be heard at bail reduction hearings. So when bail is being reduced, you have a right to be heard. That's a right beyond just showing up. So you have a right to say something in those situations. And then employer cannot discharge, discriminate, or retaliate against victims of domestic violence who take time off to participate in the court proceedings, to make shelter arrangements, to do other things around safety planning or attend counseling. So that's an anti-discrimination law that should be part of our anti-discrimination trainings and all of our employer trainings in California. So it's kind of like a special circumstance. It's the same special characteristic that cannot be discriminated against, like race, sex, pregnancy, various forms of ability, different forms of anti-discrimination protections. Domestic violence is one of them in California. Then it prohibits an inmate convicted of stalking to be released within 35 miles of the victim's residence or place of employment. So that it provides like a little bit of a safety net. It also provides a little buffer about time, because you can imagine if a person convicted of stalking is released next door to the victim's residence, it could cause harm. Having it moved a bit provides more time for survivors. Again, think organizations and folks looking at the impact of the criminal justice system on poor people, on communities of color, can point to this as showing that this is going to create a big burden on the person who caused harm or on the person that was convicted. And it is a burden on them because moving 35 miles away, being released 35 miles away may be taking them away from their families and their support systems as well. But it is, as of now, part of the protections around stalking in California. The next one is the right to learn the custody status of defendants prior to conviction. So knowing whether the defendant is in custody is incredibly important for survivors. And being able to have that notice is something that people are going to need to ask for. It's not going to be necessarily volunteered, but survivors have a right to know and learn. The next piece is very similar to Marsy's Law, right? The notification of release or escape after conviction. Again, you need to request that. So if that is important to you or the survivor you're working for, you want to request that formally, hopefully in writing, when you're talking to law enforcement, that you want to learn both of these things: the current custody status of the defendant. You can ask for that. You can also ask for notification on release or escape. And I think it's good to, I'm not sure how many folks are really escaping from these from facilities right now, but if they are, having that notice in a timely manner is going to be really important. You will notice that none of these laws say have a timeline. So, basically how it's handled is a reasonable amount of time. So it may not be immediately when it happens, but it should be within, I would argue it would need to be within hours of release, because that is an hour can be enough time to travel 35 miles or wherever, and turning a corner and seeing someone that caused you harm with no prior knowledge is can be incredibly traumatizing. So the next piece is it requires a legal presumption in custody to the perpetrator of that custody to the perpetrator of domestic violence is detrimental to a child. Now, I know I don't know if we have any family law lawyers or folks that have worked with family law before. We know that this presumption can be used against survivors. I've heard of judges thinking that people are just making up cases of domestic violence in order to get custody. And I've even heard of attorneys recommending to survivors not to go for the legal presumption because it'll make you look bad. The judge will just think that you're trying to play the victim card. And it really is very telling and part of our history of victim blaming in this nation that we continue to demonize folks that speak out about domestic violence. And really, the studies are in that the custody to a person that is causing harm, you know, there is correlated child abuse when there's domestic violence in the house. And we know that it may not be in the best interest of the child. It should be taken into consideration when making custody decisions. But I know in California, we're experiencing a backlash from this victim's right. So I wanted to pause there. That was kind of domestic violence rights. There is no requirement that there's a card, but I think advocates and law enforcement should be really aware of these rights and should be able to have these readily available for survivors when they make contacts with support agencies and with law enforcement. Again, as far as enforceability, it would be for a violation of these rights or a violation of law, you would have a case against the person that has done that. For the employer piece, that could be similar to like a Title VII discrimination case under California state law. So around employment discrimination case, that could be administrative or it could be in the civil legal process.
Emily, we have a question in the chat. Folks are wondering if there are additional considerations to think of when applying this to a campus environment.
Yeah, I think that you also need to incorporate your Title IX protections in this as well. So Title IX provides for some victims' rights and protections that are connected to how they participate in that process. Also notice and rights around who is a mandated reporter of who's required to file a Title IX case. We know that that includes a lot of campus staff that will have to report if they have knowledge of sex discrimination. Being able to enumerate that included in these rights would be really important. Another piece for campus is making sure that there's connection to local campus police, but also to other law enforcement agencies, as well as when you have local campus advocates or victims advocates, also having community advocates that have separate protections, may have on-campus related protections for survivors. And part of being trauma informed is really letting survivors know that they don't have to just go to one office for support, that they could go to someplace else. There's another requirement under Title IX, which is the right to reasonable accommodations that I would also include in this, being able to tell survivors that they have a right to reasonable accommodations and they have a right to those accommodations before there's been a finding in their case if they're doing a Title IX case. Actually, there's quite a few rights around Title IX that could be could create its own card. And perhaps that's something we could explore as Valor to create through the campus program, because you can take the larger state rights and include the Title IX and the sex discrimination rights at the state level to create a very long card, but you could probably create a lot of supports for survivors that would be easy to take away in their first contacts with advocates or law enforcement on campus. Another thing I would just say is we are awaiting the new rules for Title IX implementation to be coming out of this administration. And that might be a perfect time to create something for campus specific around survivor rights and the process. Because again, the great thing about rights, it's great they exist, but they're only as powerful as the person's knowledge of them. So you can have all these rights, but not know that you have them. Having that notice is what makes it trauma informed. So you're able to exert those rights.
Emily, we have a question / scenario in the chat as well. When you referred to having the right to a confidential SART exam, someone was a little bit confused because they state that doctors and nurses are mandatory reporters. So wouldn't they be obligated to report to law enforcement?
Right. So it is a tricky situation, right? So they are obligated to report to law enforcement, but your name does not have to go on the SART exam. You have a right to ask for an anonymous SART exam, and you have a right to not interact with law enforcement even if they show up. So law enforcement may show up and make a report. You have a right to not have that evidence stored under your name, and you have a right not to engage with them. That can be very difficult. That's why I really urge having folks have a support person with them that understands these rights and can say, no, the survivor does not want to engage with law enforcement. And under VAWA, I can get you the code section so you can cite it too. A survivor can have their medical information evidence taken and stored anonymously. And that's a federal law. So it trumps the state law. This is a right for survivors at the federal level. Did that answer it all right?
Yeah, thank you so much.
Great. Okay, so we're in the final minutes. Please think of any questions, start typing them in the chat so we can answer a few questions at the end. I just wanted to, I tried to pull out how victims' rights and knowledge of victims' rights is trauma informed, but I wanted to make sure that we had a moment to just think about why people knowing their rights is part of promoting healing and promoting all these really important principles of trauma-informed care. So if you could just in the chat as a way to kind of close out and get you engaged one last time, type how can promoting victims' rights and providing this information showcase and support a trauma-informed approach. And I included the 6 core principles here on this slide to kind of jog your memory. How does it promote safety, trustworthiness and transparency, peer support and mutual help, collaboration and mutuality, empowerment? And how does it promote and hold up cultural, historical, and gender issues? I would love to see what you thought. So if you would like to answer that, what you learned, how can we promote trauma-informed access to victims' rights, and how is it showing up for you? I'm going to give you some answers because we don't have as much time, and everyone might be ready to do their transition, and we're at the end of our allotted time. But trauma-informed access to rights is really about meaningful notice and education for survivors. It has to be in the correct language. It has to be in an appropriate literacy level. It needs to be timely. So getting your notice 2 years after you've reported to law enforcement is not empowerment. Getting that information at first contact of law enforcement is empowerment. It promotes choice. It promotes survivors' voice. It holds law enforcement accountable. It increases that transparency that we talked about all day. It promotes justice, and it promotes a faith in the system. Knowing your rights can really allow you to have more faith in the system because you know you have a stake in it, you know you have a voice in it. And then finally, it can promote healing for some survivors. Being involved in this process, the form of accountability they're seeking is connected with the criminal justice system. However, I would just put a caveat in that this doesn't necessarily promote healing in the same way for all survivors. And that's really important for understanding why we need a trauma-informed approach. Because one way of responding to sexual assault or domestic violence or being a victim of crime, of any form of crime, is not going to be the same for each person. It is not a one size fits everyone situation. So knowing your rights allows survivors to make choices that work for them. And that is it. I thank you so much for your time. I'm sorry we went a little bit over, but I really, really appreciate you tuning in today. I'm Emily. You can reach out. I do consulting through Pivot Advocacy, and I also work with Valor, and you can always respond to Priscilla with any questions. Thank you so much. Have a great, great day.
Thank you so much, Emily. Thank you all for joining us. We'll be sure to send out all of the slides and the recording as well. And you should be able to get those next week. And please join us for our upcoming sessions. Thanks, everyone.